So guys, we are going to start the topics of the Indian Contract Act, जहाँ से हम लोगों ने last class पे छोड़े थे, वहीं से we are going to continue from today's class onwards. Okay. So in the today's class, we are going to cover. Just one second, let me get it. Yeah, I think I have already made you understand what are the terms of the fraudulent contract. Misrepresentation, mistake, coercion, undue influence, fraud. These things we have already discussed in detail. Okay. So coming to the next part, effect of the mistake of the law and mistake of the fact. That thing also we have already discussed and decided. Yeah. Okay. And in the last class we have discussed about Section 22 of the Indian Contract Act, where we have already understood that contract caused by mistake of one party due to the matter of the fact is not voidable in nature. It is valid in nature, and it still the contract has the still the effectability upon the law. Like what we have understood, if the contract is being mistaken by the both of the parties, that means the both the parties who are the parties to the contract. For example, you and me are signing into a contract. We are the parties into the contract. So there is the mistake of fact by you as well as by me. If there is the presence of the mistake of the fact by both of the parties, then what did we understand that in the case of the mistake of the fact by both of the parties, the contract becomes void in nature. But in case of the mistake of the fact by one of the party, the contract is not voidable in nature and it might be valid in nature. But in case of the mistake of the law, the contract is neither valid, neither void nor voidable in nature. The contract is valid in nature. Only if the parties who are entering into the contract, they are entering with a good faith that they are doing the contract in a right manner or in a right way. Got it? For example, I am a party and I am signing a contract with you under any certain provisions of the Indian law, which I think that is still in effect, which I think that is valid and that is authentic in nature. And if I am signing a contract with that particular belief, with that good faith that I am doing the right thing, and the same way, you are also signing a contract with me upon that same good faith, then the contract becomes valid in nature. Got it? Even if there is the non-applicability of that particular law, even if the law which we are following, that is not an effect, even if that is voidable in nature, still the particular contract which has been made out of that specific law, that is valid and authentic in nature. Clear? So this is about the mistake of the part of the mistake under the Indian Contract Act, the validability and the validity of the contract. Okay. So basically there are three natures of the contract. First, the contract might be void or voidable or valid. The three things are there. Valid means when the contract is valid and authentic in nature. Void means when the contract is totally banned to be done. For example, if there is a contract, the child marriage, a girl who is below 18 years of the age and a boy who is below 21 years of the age, if any of the parents are making contract to marry them between each other until and unless they belong to a specific scheduled tribe, then this contract is considered as a void contract. Because under the Hindu Succession Act, Hindu Marriage Act, or under the Indian Contract Act, or under the Indian Constitution also, the marriage below 18 years, the person who is like the who has not reached up to the age of the adultity, like adultity matlab the age of 18 years for a girl, and in the case of the marriage, that is 21 years of age for a boy. Until and unless the people has not reached up to that particular age, the marriage between two of the persons is completely void in nature. That is completely ineffective in nature. So in these cases, the contract has been told as the void ab initio, जहाँ पे उसका कोई वैल्यू ही नहीं है, कॉन्ट्रैक्ट का कोई ऑथेंटिसिटी ही नहीं है, बिकॉज द कॉन्ट्रैक्ट कैरीज ए wrongful character, a wrongful object, or a wrongful nature. Clear? So, but I told you here one line, until and unless the parties who are signing the contract, they belongs to a scheduled tribe. Because we have already understood that it might be the Indian contract, that it might be the Indian constitution or any kind of the law. It is not applicable to the people of the scheduled tribe in India, because the people from the scheduled tribes, the ST people, got it? Those people are having certain kind of the characteristics upon their own ritual beliefs. Some of their rituals, like when the girl reaches the age of the 12, 13, 14, 15, they get married to the boys, okay? So they follow their own tradition, own rituals. So these laws are not applicable to them, the person who are from a specific tribe or specific tribal region. Clear? So under section 23, we are going to understand what considerations and objects are lawful and what are not. So this under section 23, we are going to understand that what considerations and objects are lawful and what considerations are non-lawful in nature. Okay. So when we are talking about the consideration or object, object means upon what topic or upon what content the contract is getting signed. For example, I am a person and I am signing a contract with you regarding the selling of a property of mine. So the property belongs to mine. I am having my own property and I want to sell my property to you. Got it? So the property I am selling to you, that must belong to a lawful object. The property must carry a lawful object in nature. And most importantly, the thing we told that about the lawful consideration. For example, you are taking that property from me, and in return, you are paying me 5 lakh of the rupees. The amount of 5 lakh you are paying to me, that must be lawful consideration. Got it? And the nature of the contract which we are signing, that must have the legal authenticity. The property I am selling you, the property I am selling you, the land I am selling, or the home I am selling, whatever it may be, that should not be disputed. For example, that should not be under any kind of the cases or any kind of the conflicts. That should be out of conflict and clear to be sold. Clear? So these are the natures when we can tell that if object or the consideration can be lawful in nature. Clear? So the consideration and objects are lawful. It is told that the consideration or object of an agreement is lawful unless it is forbidden by law or is of such nature that, if permitted, it would defeat the provisions of any law or is fraudulent. Okay, what did it say? The first thing it's told that when the consideration object of an agreement is lawful unless it is forbidden by the law. That means it should not be the consideration or object or agreement that should not be forbidden Hello. Yes, sorry. I have got a call. Okay. So, yeah, I was talking about the lawful consideration. Then, what we have discussed that about the lawful consideration, the consideration and the object must not be forbidden by the law. That means upon which the contract is getting signed, that should not be restricted or prohibited by the court of law. For example, I'm giving you a just a sample of this. Um, yeah. Lawful object and lawful consideration. Okay, these two things must be presence of the things. This should not be forbidden by law or prohibited by law. For example, if you are talking about some certain kind of the drugs, okay, drugs are strictly prohibited in India for the common public. Okay, but whatever the drugs selling or buying is happening, that is happening illegally. Okay, but if you are taking in a legal manner, it is very highly an offense to sell or buy any kind of drug. And for which, if you have been caught while selling or buying any drug or any kind of material, then you will be punished till 3 to 5 years of the imprisonment. Okay, this is the law in India. So if, for example, if you are doing any kind of the illegal drug selling and you are buying or selling this kind of drug from someone in an illegal manner, which is strongly prohibited in India, and if you are doing this kind of business, doing this kind of contract, for example, you are selling 1 kg of the drugs and in return you are getting 1 crore of the rupees. So all these consideration and object, this is totally forbidden by the law. The selling of the drugs, the buying of the drugs is completely prohibited in India. It is forbidden by the law. It is restricted by the law. So if you are doing those kind of the contract, if you are entering into those kind of the agreements, those agreements and contract will be considered as completely void in nature. Yes or no? Yes. Then coming to the next part, it is of such a nature that, if permitted, it would defeat the provisions of law or is fraudulent in nature. For example, there is the contract is of a such a nature, the object and the consideration is of such a nature. If it is permitted or if the contract is done, it would defeat the provisions of the law or is of fraudulent in nature. Okay, it means uh, for example, take an example of this. Um, you are making a contract with me that, ma'am. Uh, okay, let's take another example of this. You are giving the examination, right? Recently, if you have been seeing that there is the matter of the paper leak, like the net exam, recently the people has given the UGC net, the paper has been leaked. There is the big matlab, conflict regarding the paper leak of the NEET exam, the medical exam. And there is also medical PG examination. The paper has been leaked of those. So these paper leak things that is continuously happening from last 1 month. We are seeing in the news and the updates here, this is happening, that is happening. We are keep seeing those news. Okay. So मान लीजिए there is a person who is entering into a contract, matlab when the paper of the NET exam, the UGC NET, has been leaked. I'm talking specifically about the UGC NET, okay? The examination which you need to clarify before going to the job of the assistant professor, okay? For example, when a person, like before the paper leak, just go to the before paper leak scenario, okay? You are a professor in a particular university or particular college, and you are in the charge of the question papers of the examination. So there is a person who is coming to you and telling you that if you are going to give us the paper, the photocopy of the papers, the examination paper, then in return you will be paid 1 lakh rupees or 5 lakh rupees or 10 lakh rupees. So here the person is insisting you, or the person is kind of putting you in a condition to be greedy. That yes, do this, in return you are going to get this amount of the money. So what did you do? For the sake of the money, you sold the paper. You sold the paper which has been taken care of by you. You secretly went inside. You took the photocopy of the paper and circulated it to that particular person. And in return, you have got 5 lakh of the rupees. So here, this activity of the yours, which showed that you have leaked the paper, isn't it a violation of the law? Yes, it is. Because if you are being taken care of something, you are responsible to take the complete care of a paper or complete care of a particular examination duty. You are breaching the rule. You are uh, distributing the question papers to the unknown persons for the sake of money. So this activity of yours is prohibited by the law. Okay. And the point you are entering into the contract with that person that yes, I am ready to send you the question paper and in return I need this amount of the money. In that moment, your activity become a fraudulent activity. Yes or no? Let's take off another example. Uh, mm, just consider that you are a person, you are my cousin. Okay, there is a person who is my cousin or one of my very close relative. So that person is running a shop. Okay, that person is running a shop which is by where that person is selling certain kind of the household things. Okay, so what happens? You are the regular customer of that particular house and you are quite known to that person. So, in a certain circumstances, what is happening? I am going to your shop and I am telling you कि yeah, I need this kind of the things from you. Can you please sell me those things? You are telling yes, I agree to sell you. Okay. And as you are the regular customer or regular attendant of that particular shop, quite close to that person. So you know the things that person is selling me, those are forged. Those are those things which that person is selling to me. That is not the original product. That is the duplicate things that person is selling to you, selling to me. And I am totally unaware about the fact that I have been sold the unused or the duplicate things. I have not been sold the original product. I am unaware about the fact because I trusted that the shopkeeper is my relative and that person, whatever is selling to me, is the authentic product that person is selling to me. So, what is happening here? When here the question arises, like when, for example, you were interested, ki chalo, this is something wrong you are doing. I am going and informing that person that you have sold her the wrongful products. But the shopkeeper is stopping you and telling you that भाई ऐसा मत करो, हमने उसी को जो भी मतलब गलत चीजें था उसने हमने हमने उसी को ऑलरेडी ये सारी चीजें बेच दिया. आई हैव ऑलरेडी सोल्ड द डुप्लीकेट प्रोडक्ट टू दैट पर्सन. अभी आप मत जाओ. अगर मेरे को यहाँ पे 10,000 का बेनिफिट उनसे हुआ है ना, देन आई एम गोइंग टू शेयर 5,000 विथ यू. 50-50 आपका है, मैं 50 आपको देती हूँ, मैं 50 रख लेती हूँ. Plus, let's divide the money. Just don't inform that person that I have sold that person the duplicate products. So what you are doing, you are taking 5,000 rupees from that person and keeping your mouth shut. You are not informing that yes, the things I have bought, that is a duplicate product. And after using those duplicate products, I am suffering certain kind of the harms. So here, this activity of yours and the shopkeeper, when the contract has been done between you and the shopkeeper that yes, if you are keeping your mouth shut even after knowing the original fact then you are going to get 5,000 of the rupees. So the nature of the contract over here is totally unlawful. And here the 5,000 rupees, the consideration amount you have received, that is due to a fraudulent activity. Obviously, that is a fraudulent activity because here you clearly know that the things which has been sold to me, that is totally duplicate thing. But even after knowing that, you are staying silent, you are keeping your mouth shut because in return you are getting certain kind of the money. So here, this fraudulent activity is forbidden or prohibited by the court of law. So here, the consideration and the object of this contract is unlawful in nature, and even if these kind of the contracts are not recognized under the Indian Contract Act, this is void in nature. Clear? Third, involves or implies injury to the person or property of another. The contract which is done to make injury to certain particular person or property of another person. Let's take an example of this. Okay. For example, मान लीजिए you are having enmity with a particular person. मेरे को किसी के साथ बहुत बड़ा दुश्मनी है. Okay. So what happens when I am continuing that enmity with that person? We both entered into a big argument. And after that argument, what happens? I have been heated up. मैं बहुत गुस्सा हो जाती हूँ and I literally want to kill that person. I literally want to make harm of that person. So what I am doing, I am coming to you, I am paying you 15 lakh rupees as the supari and telling you कि आप जाओ उस इंसान को इस तरीके से उसी का मर्डर करके आओ और आप उसी का एक्सीडेंट करवा दो, उसी को घर पे बैठा दो, उसी को पैरालाइज करवा दो. ऐसा कुछ करो ताकि उस इंसान का किसी ना किसी तरीके से कोई ना कोई नुकसान हो जाए. Here, the amount I am paying you, that is 15 lakh of the rupees. And in return of the 15 lakh of the rupees, I am making a contract with you कि अगर आप ये 15 लाख पैसा ले रहे हो मुझसे, then in return आपको उस इंसान को नुकसान पहुंचाना होगा, उसको जान से मारना होगा, उसी को पैर काट देना होगा, उसी को एक्सीडेंट करवा देना होगा, किसी भी तरीके से उसी का जिंदगी तुम बर्बाद कर दो. So here, this activity of mine to paying you money and the activity of yours to take the money from me for that specific purpose, which is usually unlawful or unauthentic in nature, that is called void ab initio. Clear? The court regards it as immoral or opposed to the public policy where there is any kind of the situation which the court considers it as the immoral or opposed to the public policy, where the court realizes that this kind of the contract or agreement is totally opposing the public benefit, or this is going to cause the public property, the harm to the public property or the benefit of the public, it is going to harm any possible way, then the contract is called as unlawful and void in nature. The last point, in each of the cases, the consideration or object of an agreement is said to be unlawful. What did it say? When the consideration or the object is unlawful in nature. Every agreement of which the object or consideration is unlawful is void. When at any kind of the agreement, as we have discussed before, the object and the consideration of that particular contract or that particular agreement is unlawful in nature, then that particular contract or agreement becomes unlawful and void ab initio. Clear? Then comes to the illustration. For example, let's take the example of one or two illustration, then we'll move into the next section. A promises to pay 1,000 rupees to B at the end of the 6 months. If C, who owes that sum to B, fails to pay it, B promises to grant time of C accordingly. Here, the promise of each party is consideration for a promise of the other party, and they are the lawful consideration. This is the most important point about it is said that when the promise of one party for the consideration for the another party, okay, then the consideration is called as the lawful consideration. Okay. Now comes section 24. Agreements void if consideration and objects are lawful in nature. What does this speak? When, if any part of the single consideration of one or more objects, or anyone or any part of any one of several considerations for a single object is unlawful, the agreement is totally void in nature. Okay. So what is it speaks? If any part of a single consideration for one or more objects, if any part for a single consideration for one or more objects, or any one or any part of any one of several consideration for a single object is unlawful, the agreement is called to be void. Okay. That means if there is a single consideration for one or more object, or there is more than one considerations for a single object. Okay. If that is unlawful in nature, then the agreement is called to be void in nature. Okay. There are two things has been spoken under section 624 of the Indian Contract Act. One, consideration for many of the objects, many considerations for one object. These things are just quite reversal to each other. One consideration for many objects, many considerations for one object. These are just two alternating things as ever been said. How does it work? For example, I am just giving you an example like there is any kind of I am having is ring. Okay. मान लीजिए I am having a ring which is a diamond ring. Okay. This is not a diamond, this is a golden ring. I'm just giving you an example. मान लीजिए this ring is a diamond ring. Okay. So what happens over here when this ring is a diamond ring? This cost around some of the crores. Okay. This ring costs a lot. Okay. What happens that I want to buy certain kind of things from you. मान लीजिए I want to buy a land from you. I want to buy certain kind of the household things from you. There are multiple objects I want to buy from you. Okay. So when I am calculating the value of the objects I want to buy from you, that is costing me around 1 crore of the rupees. So equivalently, when I'm thinking, the ring I am wearing now, that is already costing the 1 crore of the rupees. So what if I give this diamond ring in consideration of these objects? It will be हिसाब बराबर. आपने मेरे को 1 करोड़ का सामान दिया, उसके बदले में आपको एक हीरे का मोती दिया जिसका प्राइस है 1 करोड़. So यहाँ पे for the various objects आपने मेरे को आपका जमीन दिया, आपने मेरे को आपका जो भी मतलब कुछ household ingredients दिया, काफी सारे objects you have given me. But in consideration, I am just giving you a single thing that is just a diamond ring, which cost 1 crore of the rupees, equivalent amount of your objects. So this is called the one consideration for multiple objects. And second condition, multiple consideration for one object. उसी को ही रिवर्सल कर दो. I am giving you my diamond ring and मैं आपको बता रही हूँ कि इस रिंग के बदले आप मुझे क्या दे सकते हो. आपने बोला कि मैम ये रिंग का तो वैल्यू बहुत है, दिस कॉस्ट 1 crore, इसके बदले में आपको क्या दे पाऊंगा. चलो इसके बदले मैं आपको अपना घर बेच देती हूँ, मेरा एक जमीन है उस वो भी आपके नाम पे कर देती हूँ, और कुछ घर का सामान है वो भी मैं आपको दे देती हूँ. सो दिस ऑल विल कॉस्ट अराउंड 1 crore, जो आपका रिंग के बराबर हो जाएगा. सो हियर द सिचुएशन इज जस्ट वाइस वर्सा. In return of the one object, you are giving me multiple consideration. You are giving me cash, you are giving me your property, you are giving me your home. So in return of the one ring, one object, you are giving me multiple considerations. And there what you are doing? In return of the multiple objects, you are giving the single consideration. In these two conditions, where the objects are more and the consideration is one, when the consideration is more and the object is one, in those conditions, the contract is a valid contract if it fulfills all the terms and conditions of the contract. But if it is not fulfilling the terms and conditions of the contract, it is violating the rules of the contract, then this will be considered as a void agreement. And especially if the object and the consideration has the unlawful nature. When the object and the consideration is unlawful in nature, is legally not authenticated, legally not approved to be done, which we have discussed before, then the contract will be considered as a void contract. Okay. So this is till section 24. From section 25 onwards, we are going to continue in the next class. This is all for today. And in next 10 minutes, we are meeting for the class of the Hindu law. Thank you.